We have a guest in the studio. We want to talk about arbitration as a method of dispute resolution. And before we welcome the guest, CT has the day's proverb.
Yes, we are still in the country of Mauritania.
Okay.
Before eating, open your mouth.
Please.
Before eating, open your mouth.
Yes.
Aye. Some things are not as obvious as you think. Aye.
Do. I thought this particular proverb was specifically obvious.
No, I'm saying you would think that it's obvious that if you want to eat something, you must open your mouth. I'm saying to some people, it's not as obvious as that. Things that you would think would just make sense. The person who said common sense is not very common. Knew what they were saying. You get where I'm coming from now?
I see what you're saying.
Yeah.
Not everything is as obvious as it seems.
Voila.
And not to everyone.
Exactly.
Okay. So if I were to speak Kenyanese, we're saying it isn't an obviousity.
What's your interpretation of this proverb, Ndu?
Exactly that.
What?
That, in order for one thing to happen, something else must precede it. You want to eat, you open your mouth.
You don't do. Has just gone this route. When you ask, can you please describe a conductor? He says, yes, I can. What is it?
It conducts.
Something else. So, okay, we've got it.
For one thing to happen, something else must happen before it.
Yes.
Yeah.
Sawa.
Are you okay now?
I'm fine.
Very good.
Okay. Lawrence Ngugi is our guest this morning. He's the registrar and CEO of the Nairobi Center for International Arbitration. Good morning, Lawrence.
Good morning.
Welcome to Kenya's biggest conversation. Welcome to the hot seat. Here we do arbitration every morning.
Okay. As I've just witnessed.
Yes. This is what happens.
I've seen.
What is your interpretation of that proverb? That obviosity.
I think I would have said, to every action there's a cause.
Mm-hmm.
And so for you to eat, you must open your mouth.
Okay.
For you to... Okay.
You know what came to mind?
Yeah.
For you to go to jail, you must be arrested.
I was going to say, in order for you to speak, you must think. But then I realized there's so many of us don't do that.
That too.
You don't need to think to speak.
You don't need to think to speak. Those two are not necessarily connected.
But you don't need to open your mouth
to speak.
Yes.
Lawrence, welcome.
Asante sana.
I see you've come with a trophy, and it's dated the 3rd to the 5th of November. We are in the 10th of November.
It's brand new.
Straight from the kitchen.
Eh? Tell us about it.
Well, it's not a cup for drinking tea or drinking water. It's a cup for acknowledging people who have excelled. So there's an association called the Arbitration Association of Africa, Africa Association of Arbitrators. It is a body of arbitration institutions, arbitration practitioners across Africa, of which the Nairobi Center for International Arbitration is a member. Every year they do hold a conference and awards ceremony. This year, the event was held in Accra, Ghana. And in that event, the Nairobi Center for International Arbitration was awarded the Arbitral Institution of the year 2022. So hence the cup.
Uh-huh. So this is it rotational, or did you get it because it was your turn to get it? How is it? What is it based on? Why did you win it?
As I understand, there are many institutions on the continent, and many were considered. A couple made it to the nomination. They were subjected to a panel of judges, which is an international panel consisting of real judges from judiciaries across the continent, practitioners of repute in the continent, eminent persons, and eventually 3 institutions made it to the last nominees. And out of those 3, we emerged the carrier of the cup. So I brought home a cup.
Congratulations.
Indeed.
Yeah. A job well done. We've hosted the chairperson of the Nairobi Center for International Arbitration, but this was a couple of months back.
Yes.
Jackie Oyuyo. Now here you are today. So let's just go back again into just descriptions and definitions. What do you do as an international center for Nairobi Center for International Arbitration?
Maybe let me begin by the name itself. So Nairobi Center for International Arbitration. If I can break down the words that describe that name and see whether we can get to what we do. So Nairobi stands for the location. That basically means we are located in Nairobi, in Kenya. The word center would stand for a center where things happen. Some activities do happen. You talk about a shopping center. In this case, we shall see what kind of a center. So the where, the what we do, we are a center where certain activities do take place. And those activities include international arbitration. So to the viewer, Nairobi therefore would stand for the head office or the headquarters of where this center is located. The center is an institution which carries on the business of managing disputes through what we call alternative dispute resolution, arbitration, and other forms of dispute resolutions which we could speak about. So why Nairobi? This is a practice that has emerged over time. You will hear of London Center for International Arbitration, Kigali Center for International Arbitration. So for the external user, the word Nairobi communicates the location of this center. For the ones who are a little bit more advanced, the lawyers especially, when they hear Nairobi, it will also communicate something to them. One of the things that they might get from that name is that likely the law that guides and governs especially arbitration, international arbitration under this center, by default may very well be the law of Kenya. So there is a trade usage that we are following, which then calls on us to then use the capital of the country where we are located, which is Nairobi.
Okay.
Yes.
Okay. And so what happens in this center, or who then are the customers of the center, and what kinds of disputes are we seeing then being resolved at the center?
Okay, before I answer that question, let me also explain that although we say international arbitration, that is not to mean that we only deal with international cases. We also do deal with domestic cases. And so now back to your question. Our customers would be anyone with a dispute, especially of a commercial nature, with an agreement where they have designated the Nairobi Center for International Arbitration as a center to which they will refer any dispute that may arise in the course of the execution of their contract, or as a contract which did not have such a clause. Later on, a dispute arises and they do refer by a subsequent agreement for us to either arbitrate or mediate or conduct another process of dispute resolution depending on their choice. Yes.
Okay. So then, if we're talking about during the course of the contract, something then may arise, how then does one begin this process? Let's say a certain amount were to be paid to one party, that doesn't happen. How then does one begin the process of saying, actually, as opposed to going to court, I want to go to the Center for Arbitration, see how we can figure that out? Or are these pre-clausal that we will go to arbitration, or is it a court-appointed process?
Okay. So let's begin with arbitration in itself, by its very nature. And assuming here Citi and Eric are in an agreement, given the kind of businesses that they run of colossal amounts.
Yes.
They do not want their disputes to be handled in a public setting, and they want their dispute handled in a more closed setting. So in that agreement, they will normally have written, should a dispute arise in this contract, we shall refer it to the Nairobi Center for International Arbitration to be arbitrated in accordance with the rules of arbitration of the Nairobi Center. So under those rules, we have a predictable, reliable process which we have already set out. Assuming it is CT who has refused to pay Eric, I'm not sure whether that's how it happens, but
Yes,
just for the sake. CT will then write to the Nairobi Center for International Arbitration, and what he shall be writing to us is a request for us to register an arbitration. He will describe the nature of the dispute, the claim he is making, and then alongside that he will be asking us to nominate an arbitrator for the purpose of the case, and then from there the process kicks off. On our end, we will engage in processing his claim. What do I mean by that? We will consider whether he has complied with the requirements of the rules, the description of the claim, the description of the nature of the dispute. Is there actually an agreement which can refer the dispute to us? There is a payment of a registration fee, fairly low amount. And then once we satisfy that all the conditions have been met, we then write to the other party, in this case, Eric. A request has been made pursuant to some agreement you have with CT. And of course, then the process kicks off, and eventually we appoint an arbitrator, and the case begins. Yes.
Does Eric have to accept?
Well, given that there was an agreement, and in that agreement they had said any dispute arising in
Shall
that
go
contract
to this particular
shall
center.
go to that center. It is unlikely that his attempts to reject will be acceptable. However, even if he did, that is a matter which shall be now addressed by the arbitrator.
Okay.
Yes.
When you select an arbitrator, when you pick the person to arbitrate this issue, do we have to agree as the two parties?
Okay. So back to the request that CT sent. That request will also have a name proposed by CT. Maybe Hussein Du would be the arbitrator. As we write to you, we inform you that actually he has already nominated Du to be the one who will arbitrate the matter, assuming that it says one arbitrator. Eric will have the right to either agree to his nomination or to counter-nominate. And once you counter-nominate, then there will be a process of between the two of you agreeing eventually who would be the arbitrator. Let us assume you are unable to. Then the center has reserved the right to make that appointment. So there will be a back and forth between the parties. Eventually, if there is no agreement, in most cases there is agreement on one person, but if there is no agreement, then it's not an impasse that cannot be dealt with. We will deal with it and appoint someone on your behalf.
Okay.
Yes.
But the arbitrators from the center then, however, are made known to all parties so that you can then have your pick from those who are in
The panel.
In the panel.
Okay, so yes, we do maintain a panel of arbitrators, people of distinction and repute. However, let me step back and state that when CT writes and makes a request, the default is that the parties nominate an arbitrator of their choice. And that arbitrator doesn't have to be on our panel. But of course, at the point in time when we shall make the appointment, there are certain conditions that need to have been complied with before we appoint the person that they have nominated. If the parties have no person that they nominate, then they can also fall back on our panel. The parties can actually write and request us to give names from the panel of people perhaps with a particular expertise, people of a particular qualification, and we normally will give names in no particular order, or if they want a particular preference of order, we also do that. Yes.
Okay. And are the arbitrators, okay, because it's a different kind of dispute resolution, an alternate one. So then will you find that your arbitrators, even though you talk about them being skilled of high repute, but that they are also experts in particular fields? Will you find that you have arbitrators along those lines, or is it just a pool of those who have gone through the training?
We will have, or we do have actually, two panels, one an international panel and a domestic panel. Within these panels, you will find people of various expertise and backgrounds and fields, all the way from marine, for instance, an expert in telco issues, an expert in energy, oil and gas, simple contract lawyers, and non-lawyers of different fields. So there is a wide and rich pool from which, no matter the contract, you will find at least somebody who has an issue in that area who can be able then to determine the cases depending on what the facts of the case, of course. Yeah.
Are there other centers in Nairobi
Okay.
for arbitration? Like, do you have competition?
Well, there are centers for arbitration, but a different kind of center for arbitration. Let me handle it this way. So arbitration can either be handled on an ad hoc basis, or it can be held in an institutional basis. By ad hoc, I mean, again, back to the example I gave of, now let's say it is Eric this time.
No, it's the same way.
City to Eric. I hope I'll get out of here in one piece.
We can move it the other way around. I've refused to pay him for this land.
Okay, so you have refused to pay him
Yes.
for a particular purchase. And your agreement actually says that in the event of that kind of a refusal, you will refer the dispute to an institution which normally just makes an appointment.
Okay.
So the only thing they will do is appoint an arbitrator for you, and then from there on.
So a contract will just be saying this matter shall be referred for arbitration without necessarily specifying the Nairobi Center for International Arbitration.
It could appoint someone else,
Okay.
An individual, a professional institution, purposely just for the sake of appointment.
Okay.
Now, then there is what we call institution-administered arbitration, which is where we fall in.
Okay.
So if your question is to whether there is another similar institution, no. We are the first of its kind in Kenya.
And the only.
And the only one.
Okay. But then we can go to other arbitrators, just like you said, ad hoc.
Yes.
And do they have to be qualified arbitrators? If our contract says we shall refer the matter to arbitration, does it necessarily then mean that somebody has to be a certified arbitrator?
No, it doesn't.
Okay.
Yes.
The people that you have in your panel, what, besides their, of course, technical skill in the various areas, do they have extra training on arbitration?
Yes. So most of the panelists on both the domestic and international panel will be holders of some qualification in arbitration over and above their primary field of practice. So you would find a chartered arbitrator, fellow of the Chartered Institute of Arbitrators. So they will be having qualifications from different institutions, universities, some the institutes. We ourselves do training, so we do also accredit arbitrators, mediators. And so depending on which institution trained, that will be part of what is considered before they are empaneled on the panel.
Okay. So what, maybe now, I guess we can go into the part now where we talk about the process of arbitration and then see then what you go through. It is a legal process, obviously, but how then does the process get carried out? Are we looking at, does it mirror that would then take place in a court? Everybody gets to say their side, of course, within the boundaries of confidentiality, one would assume. But then how does this process now start to play out once you've gotten past the, preliminary levels of, nominating an arbitrator and et cetera, et cetera?
So again, fortunately, because we are an institution that administers disputes, we have a whole set of rules which define how the process will be carried out. So once the parties now appear before the arbitrator organizes how the matter will be handled in terms of time, in terms of venue, and such like issues. Then we, on our end as a center, nominate a case counsel. So this case counsel will be the link between the center, the arbitrator, and the two or more parties who are involved in this case. So see it as a triangle. We become the point of connection between the tribunal, that's the arbitrator or arbitrators, and the parties. documents will be exchanged through us. Payments also from parties to the arbitrator for the arbitration fees and administration fees will also be channeled through the center. And then from there on, the set of rules will define how the hearing will be conducted. So there's already a predictable procedure which is expressed in the rules. You can determine the timelines within which this is going to be done. And this is the good thing about arbitration, the flexibility. The parties can agree. Certain elements, even though those rules can be custom-made for their specific dispute, it can actually even end up being what we normally refer to as a document-only arbitration. So the parties will file each their documents, and once they have compiled the documents handed over to the tribunal will sit on its own, consider the documents, and then in the end, of course, it will render a decision which we normally refer to as an award.
So it's not necessarily that there must be then human interaction to explain one case and counter and things like this. Would you say it's not necessary? So the human conversational element does not add or take away from the process?
So the default often is the parties will want to be heard. However, given the nature of the dispute, and of course the strategy of the parties, the option of having a document-only arbitration is also available. So yes, the default is that you get the opportunity to state your case before the arbitrator, but you also have the choice of allowing the matter to go by way of documents only.
Have there been cases where one of the parties is basically intent on derailing the entire process? So they will play all the hanky-panky games, they will go to court, like going to court and applying for adjournments, this and the other. I'm unwell, I'm out of the country, you're supposed to come on this day. Oh my goodness, I forgot. Oh, can we now set a new date? Such delay tactics, do you see them and how do you deal with them?
We have a name we use to describe them. We call them guerrilla tactics. And yes, they are there. There will be, so remember, by the time parties have failed to agree on an issue in a contract, very often they know what the dispute is all about. They know if it's about payment, they know who hasn't paid, and the one who hasn't paid knows they have not paid. So by the time they are coming before the tribunal, it is only that the state of things is untenable. If it was possible for the two of them or the multiple parties that they may be to agree, they would have agreed. Which means sometimes they'll come before the tribunal, some with clean hands and others with soiled hands, and not with clean hands. The ones without clean hands might employ these so-called guerrilla tactics to delay. They may want to make application after application before the same tribunal just to delay the process, or they may even call for external intervention by approaching a court and make any manner of applications to derail the arbitration from going on. Now you also ask, then how do we deal with them? Again, these rules have given extensive power to the arbitrator to be the manager of the process. And so there are tools within the rules which the arbitrator, him or herself, can apply to rein in a party who is obviously misusing the process. Again, also by design, under the arbitration law, the intervention of the court is very limited. So even where these parties who are not really interested in the progress of the case approach the court, they will be met with a law which already deters parties from using the court to misuse the arbitration process. And in those instances, you will find whether by the tribunal itself or by the court or even the center, because there are certain powers reserved to the registrar to ensure that the process is not abused.
Let's take a break. When you come back, I want to ask the question of the importance of choosing the laws applicable in a contract.
Yes.
And then also where the dispute shall be held or heard. I will use this example. Buy a credit loan agreement between the government of the Republic of Kenya and the China Exim Bank, which says Article 15 of that contract governing law and dispute resolution. 15.1 Governing Law. This agreement and the rights and obligations of the two parties hereunder shall in all respects be governed by and construed in accordance with the laws of China. And then it comes to good faith. They say that the parties hereto undertake to use their best efforts to resolve any dispute arising out of or in connection with this agreement through consultation in good faith and mutual understanding, provided that such consultation shall not prejudice the exercise of any right or remedy of either party hereto by any such party in respect of any such dispute. And then we come to dispute resolution. Any dispute arising out of or in connection with this agreement shall be resolved through friendly consultation. Full stop. If no settlement can be reached through such friendly consultation, each party shall have the right to submit such dispute to the China International Economic and Trade Arbitration Commission for arbitration. The arbitration shall be conducted in accordance with the China Economic and Trade Arbitration Commission's arbitration rules in effect at the time of applying for arbitration. The arbitral award shall be final and binding upon both parties. The arbitration shall take place in Beijing. Lawrence Ngugi is the Registrar and CEO of the Nairobi Center for International Arbitration.
This is the Situation Room, the only way to start your day.
All right, back to arbitration issues. Lawrence from the Nairobi Center for International Arbitration is here. That question, why is it important, the governing laws and the place for arbitration? In the case of that contract that I just read between the government of Kenya and the Bank of Export-Import in China, the governing laws are laws of China. Arbitration shall happen in Beijing. Why is it important?
Maybe let me go a winded way
Right.
in answering your question. We've come a long way.
Who?
Let me describe who.
Okay.
For people to trade across boundaries, we have come a long way. If a dispute should arise, there's always been the question, where will it be referred to, or how will it be resolved? History has it that in the olden days, the 1800s, nations would resort to war to resolve commercial disputes. It came a bit closer. They stopped the practice of war, and they engaged in what they called gunboat diplomacy. So if I was a naval power, I would send my naval ships, assuming you are in Kenya, and we have entered into an agreement with you. You have refused to honor that agreement. I'll send my ships to Mombasa, and I will anchor them off the coastline of Mombasa. In other words, to exert pressure on you to honor the agreement. So gunboat diplomacy.
And you would train their guns onto the shorelines of Mombasa.
Precisely.
Yes. Try.
Yes.
The French and the Haitians are very good at that.
Yes.
There's long history.
So it moved away also from that, the gunboat diplomacy. That's a hardcore diplomacy, and moved to soft diplomacy. So we send an ambassador, deliver a letter here and there, and the dispute is somewhat addressed and resolved. So we came to state arbitration. We have investors. We won't go to war on their behalf, but we will send diplomats to negotiate on their behalf with foreign nations. But as trade increased and the involvement of the state in commerce became less and less, a direct involvement, then the question was, how does a private individual and another private individual get involved in trade in different countries? Their laws are different. So we had to find a law that allows for them to resolve their disputes, even though it is not the law of their specific countries. So international arbitration developed a concept called transnational law, which allows for people in different countries to be able to resolve disputes through this law, which is not located somewhere. Which brings me to the question you've asked, the governing law, or the seat of arbitration. What do I mean by that? In a contract, there will be two sets, two main laws. The governing law of the contract, if we are to ask which law will be used to determine whether you have breached the contract or not, that is a governing law.
Okay.
And so maybe that agreement says that law is the law of
China.
Then there is a question of which law will address the procedure of arbitration, of resolving the dispute. That addresses the question of the seat. So you've asked, the arbitration will be heard in Beijing. It will be heard, handled by, it's called CITEC, the commission in China. It's an institution for arbitration. And so the parties, as they negotiate the agreement, will have made these choices. Now, of course, there are implications that they would have considered. One, which is the law closest to the contract, which is the law closest to maybe the finance part of the contract, which then brings in this element of the governing law will be this, the seat will be here, the venue will be here, and the procedure will be this institution. Those are considerations that parties normally make so that they can bring this law, which is not in both countries, to apply into their dispute.
So you're deep in thought.
I am. The thing that is again swirling around my head is you arrive at a determination. How do you enforce it?
Yes, very good question. Part of that law which you are considering, the end, of course, objective, I agree with you, City, is enforcement. And so you'll be asking yourself, if we were to arbitrate under this framework, will I be able to realize the fruits of the award, the decision? Now, again, in this, what we call the transnational law, nations have entered into conventions, agreement, treaties. One of the treaties is, we call it the New York Convention on enforcement of foreign arbitral awards. So if Nation A and Nation B have signed up to that convention, and you have adopted their law as a seat, as the anchor law for the arbitration, then it means once the arbitrator renders the award, the decision, you can work with that award, enforce it either in that country or in your own country or in any other country which is a signatory to that convention, where the assets of the party against whom the award is made are held, and enforce it in their courts.
So if an award is made, say, in Kenya, the same would apply?
It would apply because we are signatory to that convention.
Okay. So one would then, at the end of this process then is with what the resolution is, if there's an award or if there's, do you call it a ruling thereafter?
So we call it an award.
Call it an award,
yes, an
right?
arbitral award.
Now, we know that in mediation, when the process of mediation is complete, the same is then notarized at court. Does the same thing happen with arbitration? Does it then go to the local court for notarization as well?
So the end product is arbitral award. The award will be signed by the arbitrator. Let us, in distinguishing arbitration from mediation, the arbitrator is actually making a decision. In mediation, it is different. It is the parties agreeing and therefore signing a settlement agreement. Once the arbitrator has signed the award and issued it to the parties, in our case, the arbitrator will send it to the center, and the center then would release the award to the parties. The parties have the first default, the one against whom the award is made, to comply, honor it, in which case no other process is required to make good the fruits of this award. But let us assume one of the parties, in this case maybe CT, has refused to honor the award against him. Eric will move to a court, in this case the High Court here in Kenya, under the Arbitration Act, and be to seek the court's intervention to order that award be enforced against the party who is in default. And it will be enforced just like a judgment of the court. So it adapts and enforces the award.
Okay, so I'm sorry, I'm going to go back and draw the parallel with mediation. Because then again, I mean, as we've been told, mediation, after the parties have agreed, the result of the mediation is final.
Yes.
Right? It cannot be appealed. So you're saying now with arbitration, there can be an appeal in court, even though the arbitrator acts as judge in this dispute.
Okay, so just to clarify, the process of going to court to seek enforcement is not an appeal. Basically, the person works with the award as it is.
Because the other party has not complied.
So the order they will be seeking is adapt and enforce my award. So there is no appeal.
So can you appeal?
You cannot appeal against an arbitral award. It is final and binding. Unless it is set aside by a court of law. Now, setting aside is very different from appeal because appeal deals with the substance, the real question which was in dispute.
Yes.
Setting aside normally checks on procedural questions. Was the arbitration conducted as it ought to have been conducted? So it is not the same thing as an appeal. Yes. That's why we say it is final and binding.
So appealing then would be on the procedures and all, which brings me into that question, where if ICT discovers that I had seen the arbitrator, Kitambo, and we had a deal.
In fact, you went to school with the arbitrator.
And now he is basically raising questions about the arbitrator's conduct or misconduct. That's the case.
Their independence.
Their independence, right? Is that the case where now you go to appeal? Using such, or if he does that, what does he do? What recourse does he have? Can he come to the center and say, wait a minute?
Can you recuse yourself as an arbitrator the way a judge would in a court of law?
Okay. So, assuming that question is raised long before the award, right from the point of appointment, and these facts were known to City, for example, that there is a conflict of interest based on one ground or the other, then City, at the point when this arbitrator has been appointed, ought to raise the issue and not allow the arbitration to proceed, only then later on to raise it before the court that XYZ had happened. The first opportunity is when the matter comes to his attention. He should raise it then. Assuming it wasn't, and it comes...
You find out later.
Yeah, you find out later. So that could be one of the grounds for setting us. It's still not an appeal. There are limited grounds by which a party could challenge the award. That's to have it set aside. One of which is fraud. There was bribery. Another one is maybe the arbitrator handled in handling the dispute. He went beyond the dispute which was referred to him and handled issues which were not referred to him. It could be a question of public policy. So again, back to the law issue. Does the law of the country or the applicable law allow for the issue which was submitted for arbitration to be arbitrated? And such like questions. Was he given opportunity or was she given opportunity to present their case? Or were they denied the opportunity to present their case? So very limited grounds. As you can see, they are all dwelling on process and procedure as opposed to should you pay or not pay.
Now, one of the things that I'm just moving slightly from arbitration, then coming back to it, that people who have run afoul or have had issues that ended up in court with either a government agency or the government itself, even when the courts have pronounced themselves and awards have been declared, the actual implementation of that particular ruling has always been an issue. Now, in arbitration, if there's something similar, a government agency, a government department, and there's an arbitration, when it comes to enforcing and implementing it, how implementable in reality is it?
If we say that experience or empirical evidence is a good place to start.
It's usually a very good place to start.
Yes. So we as a center have handled disputes from private to private party, private party to government and the like. And in the last 7 years that we have had disputes referred to us, handled under our rules, awards issued even against government or public entities, we have not seen any that has ended up in court asking the court to enforce. What do I assume by that? Government has honored those awards. So, at least from my experience, there has been consistent honoring of awards rendered by tribunals seated under our rules.
Do you register the arbitrators?
So we do have a panel of arbitrators, and so we accredit individuals, and this is an ongoing process. So it's an open invitation for those who are qualified with experience, with proven track record, and we have a standard by which we give the requirements, and then once one has gone through the process of vetting, which is a very rigorous process, I must say, they are then empaneled on either the panel of arbitrators or mediators. And very soon we're introducing a panel we are calling the adjudicators panel.
Do they pay an annual fee to renew their position in the panel?
There is a small fee for application, just to process the application. There is a small fee again for registration, and an annual fee for renewal. Yes.
Does it go with like what we see with the other institutes like the Law Society and others? You get your renewal based on some certain points that you've gotten because you've gone through continuous, engagement and learning.
Not so.
So there's no professional learning required for you to get your renewal.
So the persons on this panel are of very high qualification. Let's start there. In fact, the qualification is literally at the apex of any qualification you'd get in this field anywhere across the globe. However, that notwithstanding, we involve these members of our panel in activities through the effective year. For instance, our training program, which we also run. We involve them in events that we hold. We involve them in mentorship programs, and this can account for CPD qualification. They also are professional members of other arbitration and mediation bodies, where they also undergo continuous training. They train themselves, and so by virtue of this consistent engagement throughout the year, we do keep them on the panel.
Under what circumstances would you strike somebody off your panel?
Of course, one of the extremes is misconduct in a case. Allegations of going in violation of our code of conduct. So we have a code of conduct. Any arbitrator appointed to handle a matter under our rules must abide by the rules of the code of conduct. And of course, if you flout any one of those rules, then we would strike out from the panel. It could also be an affront from your professional background. And so, of course, there will be various avenues by which eventually you can end up being...
So if you're a lawyer and you've been struck off the bar of the Law Society of Kenya, then you're standing within...
There would be implications also on our panel. Yes. Depending, of course, on the breach on the other side.
Lawrence, we thank you very much for joining us. And congratulations once again for being named Africa's best center for arbitration. So it's the award is called what? The Arbitral Institution of the Year.
Of the year 2022.
2022. We have mastered it's 2022. It's current.
Yes.
Karibu sana the next time.